Friends, good afternoon. There was question in advocate on court examination. The question is Section 35 of the Advocate Act 1961 includes misconduct and other misconduct, professional misconduct and other misconduct for advocates. Provide three instances of each of these situations. This is the question. As per my ability, Jeel, I'm going to answer it. You can refine it as per your desire. Friends, Section 35 of the Advocate Act deals with professional misconduct and other misconduct of advocates, and it empowers the State Bar Council and Bar Council of India to take disciplinary action against advocates who violate professional conduct norms. The provisions outlines two main categories of misconduct. First one is professional misconduct. Second one is other misconduct. Professional misconduct, violations relating to legal profession and its duties, whereas other misconduct, actions or behavior not directly related to professional conduct, but that affects badly on the advocate's character. So, friends, going further, such as misleading the court, an advocate intentionally misleading the court by presenting false facts, misrepresenting evidence, or fabricating documents to deceive the judge during proceeding. The case law is Surjit Kumar Roy versus Bar Council of India, that is 2013. An advocate was held guilty of professional misconduct for fabricating documents to mislead the court. Friends, sometimes there is conflict of interest. An advocate representing two clients with opposing interests in the same matter, or continuing to represent a client where a conflict of interest arises that affects the duty of loyalty and confidentiality. Supposing I am giving an example of one case law, that is VR Sivaraman versus Bar Council of India 2012. An advocate faced disciplinary action for representing conflicting parties in the same legal dispute. Third type, neglecting a client's matter. An advocate failing to appear in court or neglecting a client's matter causing harm or loss to the client due to negligence, unprofessionalism, or disregard for deadlines. The case law is B.K. Maheshwari versus Bar Council of Delhi, 2011. An advocate was found guilty of neglecting a client's case, resulting in client's loss of legal opportunity. Friends, there are other misconduct also. Supposing there is criminal conviction, an advocate being convicted for a criminal offense such as fraud, theft, assault, which affects their credibility and integrity in the legal profession. Case law, Bar Council of India versus M.M. Thomas, 1999. The advocate was disbarred for being convicted in a criminal case involving cheating and fraud, leading to the loss of public trust in the profession. Sometimes the behavior is also not proper of the advocate. We can say indecent behavior of the advocate in court, such as an advocate engaging in rude, abusive, or violent behavior in court, including shouting, making obscene remarks, or physically assaulting others during proceeding. Case lies R.C. Kuldeep Singh versus Bar Council of Punjab and Haryana, that is 2014. The advocate was found guilty of misbehaving with a judge and the court staff during proceeding, leading to disciplinary action. Sometimes of lesser volume, failure to pay dues or fees. An advocate repeatedly failing to pay dues owed to the bar council or the court, affecting the proper functioning of the legal system. The case lies Ashok Kumar Burma versus Bar Council of India, 2016. The advocate faced disciplinary action for failing to pay court fees and registration dues for years, resulting in suspension of his license. So, nutshell, friends, professional misconduct typically refer to actions directly related to an advocate's duties and obligations to the court, client, and legal profession, such as dishonesty, negligence, or conflict of interest. Other misconduct encompasses acts outside the legal profession, but still damaging to the advocate's reputation, such as criminal behavior, indecency, dishonoring financial obligations. So, friends, Section 35 provides the mechanism for taking action against advocates who engage in such misconduct, ensuring the integrity and trustworthiness of the legal profession. Friends, there are a lot of areas where professional misconduct or other conduct is possible, which we legal professionals duly know. So, keeping in view the status of our fraternity, we are known as officer of the court. So we should behave properly. Our first priority is to save our designation, our respect, our honor in the society as well as in the legal fraternity. Other things come later on. Money at last, social service, justice first. So this should be our motive so that our institution, which is going to impart justice and which is the main motive of creating such a vast system of courts and wars, that should be kept in mind. Rest as you like. I wanted to say what I have said. So, lot of thanks. God bless you all.